This is my 4.1 ethical and legal part 2. So ethical basically means relating to beliefs about what is morally right and wrong. That's from the Cambridge Dictionary. Ethical issues can include keeping someone's result confidential, keeping the participant anonymous if they wish, and maintain their privacy to a high level, and also data protection. So before any experiment can take place, the experiment has to go up against the ethics committee, and they will look at the complete project proposal form, and if they think that the rights outweigh the wrongs, then they will give it ethical clearance for the experiment to go ahead. If participants wish for their results to be kept anonymous, then they must respect those wishes and not share them with anyone, or to put them on a public website where people can find them. They must also be careful that if they have said their results, can be shared, to keep any confidential information, such as their name, address, telephone number, covered and not mentioned. This is also part of the Data Protection Act, so that no one apart from the researchers know the participants' private information. So legal is working within the boundaries of the civil law. So any researcher that must make sure that when they're carrying out their experiments, they're not breaking any laws. For example, if a participant has specifically asked their details not to be shared, and then the research shares them with a third party, then that would be breaking the law because they're not protecting the participants' data. So implications from scientific misconduct. If the researcher breaks any of these ethical or legal laws, then they could face implications from scientific misconduct. Participants can also suffer from scientific misconduct too. Most likely, if the participants have suffered any harm, it would have been physical harm when they have been physically hurt from the experiment and have injuries from it, or emotional harm, which could be embarrassment or having data shared which is invading their privacy. As for researchers, if the incident was small, they could be asked to take part in ethical training, which will refresh them on what is right and wrong and make them think about what they did previously. They might also be sued by the participants or fined for causing harm or breaking or damaging equipment during the experiment. If the incident is more serious than the research, then they could be given a reprimand by those who are higher up than themselves, or even suspended temporarily whilst they investigate further into what went wrong. They could also lose their professional or research credibility, so they could lose their current job, but it could also stop them from getting future jobs if a researcher is not deemed competent, and it will stay on their record. As well as this, they could also lose their BASES accreditation. And if it is a very serious incident, then they could even get prison sentences if they have broken the law. So, scenario 1 is a researcher will be investigating the role of ice baths in aiding recovery from a maximal intensity gymnastics routine. The baths are set to a specific temperature, but the participants are not told what it is. Whilst participants are in the baths, the researchers will leave them until the time is up. So, participants have a right to withdraw. They can't tell the researcher what they want, like if they want to be able to stop it, because they're not in the room. It's ethically right for the participants to be able to stop the experiment at any time they want. Not only have they volunteered for it, so can leave at any time, but they could also suffer injuries from some experiments that could potentially damage their career in gymnastics. The researcher's not watching what's going on, so that could cause health and safety issues because they can't stop the experiment if it gets unsafe, because they're not in the room to do so, and they could be sued if this happened from the participants. And also the researcher is responsible for the participants, so leaving the room will be breaching this. So deception, the researcher is deceiving the participants because the participants are not being told what temperature the bath is. And this is bad practice because if a bath is too cold and the research leaves them alone in there for a long time, then the participant could potentially be physically harmed, because in the worst case they could develop hypothermia and then could land them in hospital. This could mean that the researcher could be charged with neglectful behaviour. And it is important for the research to tell the truth, because if anything does happen, then at least the researcher has the proof that they've been through everything in detail and the participants have been told about it. So scenario 2, the 4 gymnasts are forced to take part in an experiment to see if sports drinks have any effect on their performance. They are given a form to sign which doesn't explain the experiment and are pressured into signing it. Their results are then shared on the public gymnastics website without consent, and it's put up along with the participant's name. The gymnasts should be volunteers, so the word forced means that they haven't been given the choice. They've kind of been made to join in and take part. And they have been given a form to sign, but without any explanation to what the experiment is. So there's actually no informed consent from the gymnasts, which could lead to researchers getting into legal difficulties, as this document is a legal requirement, so could face court as a consequence if there are any severe incidents. Because the gymnasts are being forced into it, they might go away from the experiment with some emotional damage if they've been made to do things that they don't want to do. Also breaching the confidentiality and data protection, because the results are shared publicly along with the participant's name. This is done without consent, so it's also breaking the data protection law, as people now know who the person is. This could not only have bad consequences for the researcher for breaking the data protection law, so it could potentially land them with fines up to £500,000 if it is severe. It could also lead to the participants being embarrassed, and could also affect their personal career if the experiment is something that they've been told by their coaches or sponsors not to do. And also, if the results were bad and it was on a specific sports drinks, then the organisations or the actual sports drink companies might suffer and lose sales, because people now see their specific brand as being bad. So the third, scenario 3, is a researcher on work experience asked volunteers for an experiment as he wanted to conduct, telling them he was a trained researcher. He wanted to see how long a gymnast could run continuously on a treadmill at a set speed. One of the participants had bad asthma and didn't have their inhaler with them. So the researcher has used scientific misconduct because he has lied about his expertise, and so could potentially be putting his participants in danger or physical harm. He might also lose what qualifications he already has, not that he would have much because he's on work experience, and it could make it difficult for him to actually get a job because it will be put on his record. Also deception, he's also using deception because he's telling the participants that he's experienced when he isn't. This is considered bad practice and is also illegal. This is because as a person on work experience they will not have a BASIS accreditation, and so they will have to have a trained researcher in with them, which this researcher hasn't got. If any injuries were to come out of this, then he could be sued by their participants, and if there are any further complaints or if it is a very serious incident, then they could potentially be taken to court for lying, then causing an injury from it. At the start, the researcher should have done a health and medical screening questionnaire to check that the participants were fit and healthy enough. Not asking the participants to complete this is bad practice, because if a person with asthma had a bad attack and they didn't have their inhaler with them, then it could lead to them being put in hospital, which means that the researcher will be asked to leave from the work experience placement straight away, or could be fined for physical harm. So scenario 4, a researcher gets 2 groups of gymnasts to do different routines after eating different energy bars to see if there's any effect. The group gets split up so that the higher ability people are in one group and the lower ability in the other. The lower ability group are then asked to sit out and observe the higher group. One gymnast gets sued for not following instructions and sues the researcher for it. So the researcher has deliberately split the bad gymnasts from the good ones and has made the bad ones sit out, not taking consideration the equality. If they were being equal, they would have split the groups so that they were even ability, so that both could take part at once. This is bad practice from the researcher, as they have to be equal to everyone, whether they are not as good as the other people. Ethically, it is wrong to discriminate people based on their level of ability. So if someone made a complaint, then the researcher may have to take part in ethical training so that the same issue does not happen again. The researcher did not get the participant to sign a participant disclaimer, so when the gymnast got injured because they weren't listening properly, the researcher got the blame and got sued by the gymnast, even this is because it was their responsibility to keep the participant safe. From the researcher's side, this is bad practice because if the participant had signed the disclaimer, then they would have had to take full responsibility for their injuries and the researcher wouldn't have to have dealt with the consequences. That's it.